unable to negotiate a release of the contract, my client was sued and received a judgment against her for over $7,000. I was retained after the business tried to garnish her wages. Ultimately, we prevailed because the contract violated federal law. However, if this bill was enacted, my client would have been able to terminate her contract after 1 year with no more than 30 days' notice. Instead of a $7,000 judgment against her, she would have been faced with owing not more than $1,000. I'm aware of other families who have also been sued, who had to file for bankruptcy because they were unable to pay the judgment. Passage of this bill will ensure that costs and fees for instruction are disclosed, including the payment of testing fees and equipment costs that are often paid in cash or check payable to the sensei, the head of the program, rather than being paid to the order of the business. And that Virginia families will have a regulatory body to address their concerns or complaints. Other states that have enacted similar legislation include New York, Maryland, North Carolina, and South Carolina. These states understand the financial hardships that can be created by companies who espouse the merits of martial arts training, character building, integrity, and discipline, but whose actions are inconsistent with these principles. Martial arts businesses should be willing to stand behind the programs they offer. You will probably hear testimony today opposing this bill. One such issue may be the registration costs. Well, to put it in perspective, based upon the current fee schedule in the Virginia Health Spa Act, a company could pay up to $800 in registration fees. However, if you look at what that means, you would have to be generating, your business would have to generate gross sales of over $2 million in order to pay the $800 registration fee. That's a small, insignificant amount to protect Virginia families, to make sure they have the right to terminate. That's all we're saying. You can have a multi-year contract. However, you do have the right to terminate after 1 year with 30 days notice. With this bill, we believe that we'll be able to assist families and address the current inequity in the law. I urge you to support this bill.
Thank you. Delta, did anybody have a question? Just one minute.
Yeah, I did. Could you, I'm looking, one of the problems when we get bills is, as you know, being a lawyer, the only thing we see is the code section you're amending. What's really relevant is all the subsequent code sections that are the protections you're trying to get. So I'm flipping through this as we're sitting here trying to get them. But can you summarize briefly? I know there's a prepayment issue, there's a refund, there's a how long till they open, there's all kinds of protections that you would like to be applied to these types of contracts. Could you just summarize what those are for us? Yeah, there's bonding and all that kind of stuff. Or I can sit here and read for the next one.
No, you don't have to. From my perspective, what the bill does, the Virginia Health Spa Act requires companies that are engaged in physical exercise training to provide protections against for the benefit of consumers.
What are the protections?
They include the ability to terminate the contract. Under this act, you can have a multi-year contract after 36 months. So we're not inhibiting the ability of a business to contract for services. The only thing that we're doing is saying you have also, in addition to that right, the ability to terminate after 1 year with 30 days notice. That's the important safeguard here. In addition, there are bonding requirements, there are registration requirements that are consistent in this would be consistent with what other states are doing, like New York and Maryland and North Carolina and South Carolina.
Mr. Chairman, follow-up question to that. In the fiscal impact statement to this, it says the type of contract offered by most martial arts schools is not the type of bondable contract that requires organizations to register. Are these not the type of contracts that fall into the bondable provisions in here?
I think the Attorney General's amendment addresses that so that those companies would fall under that. Because the Attorney General's amendment, I think there's a sale of memberships, and what the amendment does is to say, or if you have a contract for services, for the right to use services. Most contracts for karate schools are not a membership contract, a sale of a membership, which is how the current law is written.
So when you, Ms. Chairman, the services you're talking about is where it says privilege to receive instruction in a particular form?
Correct.
Is that what you mean? And
Exactly.
So because dojos are not contracts for membership or contracts for services, whereas health spots are usually contract for membership as opposed to services.
You have the word sale and sale of a membership.
So because it's calling what is really a contract for services a sale now, you think it becomes bondable because of the use of the word sale for services or sale for instruction?
No, what it's saying is that what that amendment does is say, in addition to a sale for memberships, if you have a contract for the sale of services, for the right to use services and receive training, that would then include.
And so, Mr. Chairman, one more follow-up question. The fiscal impact statement says the reason there is not a fiscal impact is because these aren't bondable contracts.
I believe that fiscal impact statement was written before the amendment.
Right, and so what you're saying now is they are bondable contracts.
They should be
So
bondable
then,
contracts.
if I'm reading the fiscal impact statement right, that's going to mean there's now a fiscal impact. Because the fiscal impact statement, as we got it, says there isn't a fiscal impact because these aren't bondable. If they are now bondable, then there would be a fiscal impact statement. Fiscal impact, would that be logical?
Yeah, but if the registration fee that would be collected would support whatever fiscal impact the state would incur.
Yeah, I mean, I guess, and you're sort of in, I'm sorry, Mr. Chairman, we're sort of in this weird procedural place because we rely on the fiscal impact statements that we have. I think the amendment would take a reevaluation of the fiscal impact question because the issue that's preventing the fiscal impact has been amended. The problem is, I don't think anybody's going to show up in the next however many minutes to give us a new fiscal impact statement, and we're running out of time. And I think bills had to go up to appropriations.
Oh, okay. All right. Anyone else wish to speak in favor of the bill? 598. Anyone in opposition to the bill? Thank you, ma'am.
Hi, Mr. Chairman, members of the committee, Nicole Riley with NFIB. I've had a couple of members who operate these facilities that have gotten in touch with me here just recently. They do have some concerns about the unintended consequences of this. I think they do sympathize with the person that spoke before, but they do feel that this could actually impact them negatively with whether or not they'd be able to reach that bonding, and because of the fiscal impact that it could put on their business. So, we would maybe like to see this maybe at least carried over to look over, work with the patron, because we do have some concerns that they're not going to be able to meet these new requirements.
All right.
Thank you.
Thank you. Anybody else in the audience wish to be heard for or against? Yes, ma'am. Yes, ma'am. Yes.
Thank you.
And Mr. Chairman, if the AG's office is here, could they maybe head towards the front?
Hello, my name is Natalie Lago. I live in Hampton, and I've experienced a negative experience with signing my daughter up to a judge, and I was taken to court. I actually stopped the contract because of the deceptive manner in which I thought it was entered into, in terms of additional fees that were not laid out, etc. And my daughter also lost interest in it. Now, she was 8 years old when she signed up. By the time of 10 years old, she said, forget it, I don't want to go. It caused a lot of conflict within our family, and it was just a bit too much, particularly the financial pressure. At the end of the day, after we were taken to court for not paying the rest of the contract and not being able to come to a mutual decision to get rid of the contract, we did prevail in court because of the contract violating federal Truth in Lending Act. I have to tell you, when I went to court, there were at least 4 other people in court for the same thing. This is affecting, I know, in our area. I went onto the state the website where you can look up cases. There have been literally pages and pages and pages from just one dojo of people taken to court getting default judgments. This is a serious, serious problem. It is negatively affecting financially and also in the social, in their home environment, this particular
Mr. Chairman,
cause. So,
question to the lady, please. Ma'am, I understand the situation, but based on this bill, what we're talking about now,
yes.
which is different from what happened to your family. So I'm sorry for. Based on this bill, what's happening now, you have a problem with this bill. It's different than what have happened. I heard what you're saying, but what happened to you, but based on what the bill is saying now, this bill, you have a problem.
Well, I do want to ask one question, which I hope you all can find out. I've asked from the Attorney General's office, from the
Chairman,
Financial
Chairman.
Agency.
Mr. Chairman, I was asking a question, ma'am, a question that based, I understand what you were saying, what happened to your family, which I'm sorry for. But I'm talking about based on this bill,
Yes.
what we're doing now.
Yes.
Not based on what's presented to us now. We have a problem with what's before this bill, not what happened to you.
Are you for this bill or?
That she can answer, yeah.
Can I read the requirements for a bond, and maybe that will address some issues here that are being raised. The statute reads that before you can enter, that bond must be secured if the business accepts more than 1 month's fee or has an initiation fee.
So you don't really have to have a bond if you're just going monthly.
Exactly. Or, and most contracts don't have an initiation fee. The contract is $1,000, $1,100. You pay on a monthly basis $150 up, but that's it. So to answer your question, or to clarify my answer to your question, unless the company fit this criteria, and it probably won't, that's correct, there won't be a bond required. And this is under the Title 59.1, Section 306.
Mr. Chairman,
Yes.
the young lady who spoke, who wrote this small finance business, I believe. Yes, ma'am. Question for you. Mr. Chairman, notice you constantly get before the committee sometime, you say, I wrote that 5,000, I'm right, 5,000 members.
Right.
And then, so this question shows, you want to delay this because a couple of your members came to you, so they got a concern.
Right, well, they asked me to make their concerns or report the committee because they couldn't be here today. So that's why I wanted to at least bring it to your attention that they did have some concerns. Because one of the concerns they also have is if they host events, those events are actually regulated by the Department of Professional Occupational Regulation, D4. So you can now have 2 agencies that are potentially regulated.
Mr. Chairman,
So, yes, sir.
knowing that you're here, I see you here every day,
Yes, sir.
and so you wrote in, you do a good job.
Thank you.
But don't you think about this time that you want to delay this, and you're here every day watching this, how come you didn't catch this before now? Why should we delay it now? And why you didn't catch it before now? Why should we delay it when you're here every day?
Well, that's because I did not catch this bill, but my members finally heard word of the bill through, unfortunately, they within their industry sector do not have a really good network, so they got the word very late. Thank you.
All right. Delegate Miller.
Thank you, Mr. Speaker. Kind of just right on the flip side of what Delegate Spruill was just saying. Senator Locke, can I ask you a question? I have a lot of mixed martial arts types facilities in my district with a lot of parents that use it, including their children. And this is the first I've ever heard of this problem. So it's kind of same kind of questioning Delegate Spruill had on the flip side. Have we heard of this happening do we have any other examples except for this one bad character that happens to be down in your district? Do you know that?
I heard of this one, that's in my district, as well as one in Northern Virginia, and that's why it's here. And also, the reason that NFIB is here is because there was an outreach to them. They didn't reach out
Right.
to us.
Well, I appreciate you reached out to them, but you may not have it all. Do you recall which facility or what studio it was in Northern Virginia?
I don't recall the name of it, but I learned about it as I was trying to research, seeking help for myself, doing searches in, I read a forum called DC Urban Moms and Dads with Services. A lot of the people on the forum are from Northern Virginia, Fairfax, and there were a number of complaints from similar to mine. And it goes back, people were talking about it 10 years ago, lots of complaints to Attorney General's office, taking down these companies, small claims courts, but you can rarely prevail. In our instance, and Carol represented me, We were the first company ever to prevail against that martial arts class in Chinese business, and they've been open since, what, 2000?
This is the one in Hampton Roads, Mr. Chairman, if I could have a
Correct.
question.
So there's a catch-22 dilemma where lawyers don't think it's worth their while to take it to court, and people are afraid to go on their own.
Okay.
So that's how that.
Senator, for Senator Locke, if I could, I mean, Senator, again, this is, and I admire you doing your work for your constituents in this case. But keep in mind, I have a lot of constituents too, including owners of these businesses. And before I can support a bill like this, I really have to have the time to reach out to them to find out what's going on, to find out if there are bad actors in my region that they know of. Because I'm sure the good karate studios, the ones that aren't causing these problems, probably get just as disgusted as the karate facility where her family used. I mean, the rest of them probably are just as disgusted as bad actors like that. And that would be my concern, is putting all of them under this regulation, this type of regulation, without me having ever heard of this problem once in my district. And it would be very good for me to find out, I don't know if there's a way we can get more information over the year to find out how much this is actually happening across the Commonwealth of Virginia. Because again, for me personally, Senator, I simply couldn't support something like this without talking to some of the facility owners in my district to find out if this problem is actually happening.
And I think that what probably is the case is what has already been outlined to you, that many folks just don't bring it through because they don't feel that it's worth going through the legal ramifications of it. And don't get me wrong, I had a child go through a black belt. It was a very good studio for which there were no problems, you know. But on the occasions when we do run into folk who undermine the process, I think that it's our responsibility to fix that process.
And I would agree, Senator. I would just say that, you know, my children having taken karate years ago, and other children I know, trust me, I hear in my district when a bakery bakes a stale cupcake. You know, I hear complaints all the time, and I just have not heard anyone complaining about this sort of issue with judo or taekwondo or hapkido, I mean, you name it, karate, kung fu. None of the studios I've ever heard this type of complaint. So just want to let you know that's where I would have to be with this, and I'd definitely be willing to look and listen to this legislation. I just have to find out if it's, you know, I'd like to investigate in my area and find out, is this going on? If it is it just 1% of the studios across the Commonwealth of Virginia that are doing this? And if so, could we find something that goes after them directly and not every single studio, including the one that your child went to and became a black belt? And that's where I would, that's where I would fall in this type of issue.
Delegate Farrell?
Yeah, Mr. Chairman, I understand what Delegate Miller's saying, but Delegate Habib, we got off the Courts of Justice Committee issue here for a little bit, so I just want to make sure for non-lawyers. So basically what happens is you sign a contract for the dojo, and it sounds like it happens to be a long-term contract, correct? If, Mr. Chairman, if I may have just a couple of series of short questions. So usually, what is it, usually a year?
A year contract, however, you're going up to black belt, it could be, 3 years, 4 years,
So-
I have a black belt son and I have another son. And we have the year contract.
So basically, what I'm hearing is you go, something happens, you don't want to do it anymore, you go to cancel the contract, and the dojo owner is saying, no, I'm not going to cancel the contract.
Correct.
And, well, isn't that a contract that you've signed? I mean, I hate to say that, but what this basically cancels the contract. What we would
No,
do
not
today.
existing contracts. No, that's not correct. But the only thing this is doing is saying if I have this bill is passed and I enter into a contract, I can still have a 3-year contract. However, this is saying that if at the end of 12 months, Johnny is now interested in swimming and dancing and not karate, or I'm dissatisfied, or I can't afford it, or in my client's case, she lost her job. After 12 months, with 30 days notice, I have the right to cancel it, and there's no punitive, there's no penalty. I have that right. And
But it's
so the
after
question-
12 months.
After 12 months, just like if I were to join a Gold's Gym or someplace else, as an adult, I have the right to cancel after 30 days notice. under this act. And what I have researched is that other states, our surrounding neighbors,
Doing this.
include martial arts schools within the context, exactly. And that's why the bill was
So
amended.
there is a 12-month, you have to endure it for 12 months, basically.
Well, yeah, but you can still, we're not prohibiting the business from still engaging in a 3-year contract.
All right, Delegate Hugo.
Mr. Chairman, I'm not sure I'm against the bill, I'm just not sure I'm for it. I think there's just a lot of questions like Delegate Miller was asking. You know, I'd ask him to follow up on what NFIB was suggesting. And I'd make a motion to carry this over.
Second.
All right, have a motion to carry over, Central Rule 22. Any more discussion?
Mr. Chairman.
Any discussion on that?
Yeah, speaking of the motion,
Yes.
and I support the motion, and let me give you just another example of why we need to study this thing more. Something that nobody has said is once you become subject to the Virginia Health Spa Act, you become subject to the Virginia Consumer Protection Act. Virginia Consumer Protection Act has all kinds of litigation-related changes in the rights that you have in attorney's fees and lots of other things, and how those costs impact these contracts. I think it's something we need to spend a lot more time with. With all due respect to my former colleague on the Civil Subcommittee, 2 spots down to my left, I do think normally when we have a bill that gets in the Consumer Protection Act and presents all those issues, we do let the Courts Committee take a look at it. I think this very well may be a real problem, and I have 2 kids who lost interest in their contract for karate about 2 months into it, and I just view that as tough luck as a dumb dad who signed a year contract. But maybe we do need this in there, but I think delaying it so we can look at it is the right approach, and I support the motion.
All right.
Mr. Chairman,
Yes.
I'm hearing what the folks are saying at the end. If we are honest with each other, how many times, because what committee that you are on, how many times has someone come for that desk right there and presented a bill? You have no idea of what they're talking about, but you listen to the facts and you ask questions. And none of us have said, well, I'm not nobody, I gotta go back home and talk to people in my district. How many times? Not a one. 9% of the time the bill that come up from this committee, no one has ever asked a question. Well, I gotta go home and talk to my folks about it. You ask the question right here, you lay it, put it up. No one has said, I gotta go home and talk to my folks.
Well, Mr. Chairman, since that was obviously directed at me, I'd like to tell the delegate, he obviously doesn't follow me closely. I'm glad he doesn't.
I do that. I'll follow all Republicans.
But to answer his question, but to answer that question, Mr. Chairman, I do that. I have done that dozens of times. So let him know.
Thank you, Mr. Chair. let's bring this back 5,000 feet for a minute. But for the exemption for a judo or karate facility, it would fit in the definition of a health spa. And that exemption is leaving consumers vulnerable, and we have seen there are people taking advantage of those consumers. And so I think what we're seeing is, by giving them that exemption, they've abused it. And that's all this bill does. It's not that complicated.
All right. There's a motion, and the motion is, we're going to vote. Motion is to carry over pursuant to Rule 22. All those in favor say aye. Aye. Opposed?
No.
Noes, raise your hand. No, raise your hand. We can get the vote correctly. Thank you, Senator. Delegate, see Senator Barker. All right, Senator Stanley. Senator Stewart. Don't hurry on Senator Barker. Senator. Yeah, you gotta.
I'm not sure how to take that, Mr. Chairman.
Well, I mean, I could have said hurry on Senator, but that would have been. Senator Stewart, Senate Bill 48.
Thank you, Mr.
And
Chairman.
said all the folks that are going to be speaking, or and I want to try to limit this a little bit, so because it could get long, and I know a lot of us have other meetings too. But all the folks that are going to be making your way up here that are going to be testifying. Thank you.
Thank you, Mr. Chairman. Senate Bill 48. Mr. Chairman, first let me tell you what it's not. It is not an anti-fracking bill, and it's not a ban on fracking. When we go into courts, Delegate Bell likes to say, what's the problem and what did your bill do to fix it? So I will approach it that way. What we have is there's a company, Shore Production. I think those folks are here today. They've been acquiring a lot of leases to do fracking in an area called Eastern Virginia Groundwater Management Area. And what that area is from about Hanover. Well, I'll tell you. Okay. From about Hanover County up to southern Stafford to Arlington County, on down to Virginia Beach. It includes all of the Hampton Roads area. We've got a giant freshwater lake, and it's not groundwater that's matriculating through the ground like you would think of where you have shallow wells and such. Maybe in your part of the state. This literally is a giant lake of fresh water. That's what they're feeding. So, in order to extract the product, either the gas or oil, whatever they're going to extract, they've got to go down through that giant freshwater lake, which, by the way, supplies drinking water to some 900,000 people in that region, including all of Hampton Roads and Virginia Beach, and up into northern Virginia, and all of the businesses within that area too, including all the seafood industry. They then fracture the rock beneath it and draw whatever the product is back up through that lake. Mr. Chairman, I talked with David Paler. He says this can be done safely. The problem is DEQ has absolutely no authority to interject what they would view as a safety measure into the process. They are advisory only with the Department of Mines, Minerals, and Energy. If you look at the bill, it says that DEQ can make recommendations to DMME, but it doesn't say they have to listen to them. So what this bill does, and the only thing this bill does, is it says DMME has to incorporate those recommendations from DEQ to ensure the integrity of that aquifer. It's just a safety measure. It's not trying to stop them. I am as pro-drill American as anybody in this room, and I am as staunch of a property rights advocate as anybody in this room. But, Mr. Chairman, as we think about this, drinking water is extremely precious to all of us. Now, where you come from, it's a little bit different. We all rely on this underground aquifer for our drinking water. We don't have any alternatives yet until we get into reservoirs and things like that. Mr. Chairman, I took the time to meet with everybody in this industry, and there were probably 12 people in my office before Christmas. We absolutely came to an agreement. There's a bill before you that everybody in the industry, including the folks from Shore Production who've gotten the leases, agreed to. They spoke for it in the Senate. They supported the bill. Now I understand, and they've somehow changed. I understand that they have a concern about one portion of the bill, so I'd like to address that, Mr. Chairman. If you go to line 192, there are the words "used best efforts" after "shall," and again after "shall" on 193, "used best efforts." I can't make a motion, but I think it would be beneficial if those that language was strict and those two "used most best efforts." It gives DEQ a timeline to adopt these regulations and to say what has to be in this EIS. They object to best efforts, and they want to drop dead date, and I'm fine with that. DEQ says they can get it done, and that is exactly what they stood in my office and agreed to. Mr. Chairman, all I'm trying to do here is, if we're going to do this, and I support doing it, I want to do it safely. And I look at Delegate Marshall because he's got some experience with dealing with this issue right now. You've got a pipe through a river with coal ash that burst, and that's all I'm worried about. That can happen. I've met with these folks in my office. I asked them two questions. Can you give me some level of comfort that there's not going to be an accident that contaminates this aquifer, because if it does, the aquifer's done for 10,000 years. We can't use it. And the gentleman very honestly said, Senator, no, we can't. Accidents happen, and it could contaminate this aquifer. I said, okay, if that happens, what are you going to do to provide drinking water to the folks who rely on this aquifer? They said, we don't know. So then we began to discuss what was fair and reasonable. Mr. Chairman, I will tell you, we drafted a bill, and I included every provision that they wanted in the bill and that they agreed to. And that's the bill I bring before you today. I would ask that those two provisions of best efforts be stricken out.
So it's on line 192, you strike after shall, strike use best efforts.
Yes,
to.
Mr. Chairman.
Use best efforts to. So I have a motion on that.
Move to adopt the amendment.
And on 193 also, same amendment.
Yes, Mr. Chairman.
All right. All those in favor say aye.
Aye.
Okay, opposed? All right, that takes care of that issue.
And Mr. Chairman, you all have heard a lot about this bill, that I'm an anti-fracker and all this. Well, I'm a lot of things, but I am pro-drill America, and I understand the significance of getting away from foreign oil. I'll tell you that every bit of this gas is going to be exported. We're not going to use it here, and that's fine. It is a very small amount. It's an insignificant amount in the grand scheme of things, but it's wonderful that these folks can sell a lease to extract it from their land. All I'm asking is that we let DEQ impart to DMME whatever reasonable regulations we need in order to ensure that it's done safely.
Well, they can already advise them, is that what you said?
Mr. Chairman, they can give them advice, but DMME doesn't have to listen. They have to listen to this bill.
Delegate Lee may have a question.
Mr. Chairman, I had a few questions, and they're for the patron. Would this be the appropriate time to ask them?
Unless he wants to have his witnesses.
I'm happy to
That's fine now. Okay.
I've got three questions on three different parts of the bill, so I just wanted to see if I'm understanding them right. My first question is in the section which is around line 98 on the version that I have